Hello and welcome to the stream. I'm Ahmed Shahabuddin. Today, could a U.S. Supreme Court case break the internet? We'll look at cases that are challenging what's known as Section 230, the shield law that protects social media and tech companies from being held accountable for harmful content posted online. The court's eventual rulings could have a major impact on the future of content moderation and internet free speech. Of course, we are always interested to hear what you have to say. Just jump into our live YouTube chat, share your questions and comments, and be part of the stream. With us to discuss this is Megan Yorio, Senior Counsel with the Electronic Privacy Information Center, also known as EPIC. And in San Francisco, Julie Owono, Executive Director of Internet Sans Frontières, or Internet Without Borders. And in Oakland, California, Mukund Rati of the Electronic Frontier Foundation. He's an attorney and legal fellow that focuses on free speech litigation. So many things to discuss here, a complicated topic for people who are not caught up. Welcome to you all. I'm going to start with the basics, Julie. What is Section 230?
Thank you, Ahmed. That's a great pleasure to be here. Well, it's important to remember that basically regulation of content moderation by social media, because that's what it's about, is restricted in the United States by the First Amendment on the one hand and Section 230, which we're talking about. The First Amendment limiting or preventing government from making laws to force interpretation of freedom of speech. But what does Section 230 says? It says on the one hand, 230C1 says on the one hand that platforms are not publishers and therefore they're not liable for the speech on their platforms. And second aspect of Section 230 is Section 230C2, which is also referred as a takedown clause, and states that platforms can remove any material they deem objectionable for any reason. So we do see that platforms do have some freedom to decide what they want.
And I guess when we talk about Section 230, I'm really interested in how it's kind of shaped the modern internet, if you will. Megan, it was supposed to incentivize tech companies, if I'm not mistaken, to moderate their platforms. Is that what it's doing?
That's exactly what it was meant to do, but almost immediately courts misread Section 230 to immunize companies for any decisions they made about publishing third-party content. So since so much of what internet companies do can be categorized as publishing third-party content, Section 230 has eliminated a lot of potential liability for tech companies. And as a result, it's encouraged some pretty bad behaviors that disproportionately impact marginalized groups. So, for instance, Section 230 has allowed tech companies to ignore and even encourage harassment and abuse on their services, because companies claim that the harm comes entirely from third-party content. So, there are... Go ahead.
No, I was just gonna, sorry, I didn't mean to interrupt, but it's almost a bit confusing. I want to try to clarify this a bit. Maybe Mukund, you can help us out, and then we'll dig a little bit deeper. Does Section 230 give freedom to platforms to kind of decide what content would be deemed, acceptable for their spaces, their platforms, and what content they would moderate without government intervention?
So to be clear, Section 230 was not meant to only incentivize platforms to take down content. It was meant to protect their content moderation decisions in general. And some of the court cases that led to Section 230 involved people who were upset about what other internet users said about them on blogs and forums. They sued those platforms, and Congress was worried that if people were able to sue because certain content was not taken down, not just what content was taken down, that platforms would not be able to evolve and we would not have the flourishing internet that we have today. And there's no denying that there's a lot of problems with content on these platforms, but it's not just what's left up. There's a lot of very good content, including when we were talking about the Gonzalez case, which involves content related to terrorism. When platforms start going after bad content, especially the big platforms that are using algorithms that are frankly not very well tuned, because it's hard to do for millions of pieces of content every day, you start taking down content not just by terrorists, but about terrorists. Not just terrorist propaganda, but from human rights organizations explaining what are the bad terrorist acts that have happened and what are we doing about it. Those things get caught up in the net also.
And I'm
so
glad.
A strong Section 230 is necessary
Okay.
protect platforms from a lot of these lawsuits.
So you're saying it's necessary to protect platforms. You also brought up the Gonzalez versus Google case. And for those who don't know, it's a very specific type of online interaction with huge implications, which we're going to talk about. And it's basically a lawsuit that stems from an Islamic State shooting in Paris that killed student Noemi Gonzalez in 2015. And her family is arguing that YouTube had recommended videos by terrorists and therefore violated laws against aiding and abetting terrorists. Now, I want to get into all that. Before we do, though, this video comment was shared with us by John Bergmayer, who's legal director for public knowledge. And it raises some interesting questions that'll lead us directly into the Gonzalez versus Google case. Take a listen.
The internet's changed a lot since 1996 when Congress passed Section 230. Section 230 is responsible for a lot of the growth of the internet and quite a bit of what people really like about the internet. And it is in part responsible for what a lot of people don't like about the internet. And it's completely reasonable to think that the law should be changed to meet today's environment. However, the Supreme Court is really not the correct avenue for that. Effectively, the plaintiffs in this case are asking the court to rewrite the law and overturn decades of precedent in a way that I think would effectively overturn the law, and it would throw out the baby with the bathwater.
Julie, John says the Supreme Court is not the correct avenue for that. What do you make of that?
That's an interesting take. It does highlight the fact that this case does raise issues that go way beyond recommender system, that go way beyond just Google, and that really interrogate, can we hold companies liable for recommending terrorist content? That is an extremely fascinating question. Right now, from our position, it would be difficult. First of all, it would require a very strict agreement on what terrorism means, because today we're talking about ISIS and the likes, but we also know that there are various understandings of what terrorist organizations are. And this is very visible on another issue related to content moderation, because platforms do have lists of organizations that are forbidden and that are considered violent or terrorist. So that's the one thing. The other thing is, if we were to change in the manner that is asked from the Supreme Court, if we were to change the current regime, it would basically ask those platforms to not only review the content that is available, that's already available, but also to review the recommendations themselves. And this would give yet another power to platforms, not only to decide what the content is, but also to decide what you will be individually able to see. Whereas we think the way should be different. It should be user-centered and user-controlled.
I think.
Go ahead.
I think Julie's pointing out something really important, which is that the way we draw lines in the free speech context has massive ramifications, not just for the bad people that we're trying to target and the platforms who are making concerning decisions here about their content, and they deserve criticism for that. But drawing lines on speech is something that this country, under the First Amendment, as Julie mentioned earlier, has always been very wary of. This is a new context when it comes to free speech, but it's not a new issue. This has always been a question of, we have bad speech. We have people using their speech to do really terrible things, to recruit people to terrible causes. But the solution is not to make that speech illegal. The solution is for users to have more freedom to create their own platforms where they can exercise their First Amendment right to say, this kind of content we want, this kind of content we don't want.
Yeah.
So Section 230 is really just enshrining in law the fundamental free speech principles that the First Amendment already protects. And the Supreme Court should not mess with those principles. And I don't know if this is what John in his comment was getting at, but Congress should not be amending and weakening Section 230.
So Mukund, go ahead. Yeah, Megan. I mean, I know your organization's against Section 230. What do you make of Mukund's argument there?
Well, we're more for returning Section 230 to its original, very narrow purpose. But you know, one of the things that really struck me about the oral argument in Gonzalez was how the justices seemed to think that their job was to engage in this policy making and making these very nuanced decisions about what kind of liability there should be for algorithms and such. And first of all, that has very little to do with Section 230. That has to do with the underlying liability statute, which entirely agree with everything that the others have been saying about liability for terrorist or terrorist-related speech. But it doesn't mean that we need an overbroad Section 230. It means we need to limit these laws or knock down these laws that interfere with speech. And what the court should be doing instead is to what the courts are meant to do, which is interpret what the statute says. And so little last week had to do with that.
Okay, it's so interesting.
Ahmed, if I could
yes,
give an
please,
example
Mukund, go ahead. Go
this.
ahead, Mukund. Go
If
ahead.
I could give an example on this front, a few years ago, Congress passed a law, SESTA FOSTA, that weakened Section 230 for content that Congress thought would be related to sex trafficking. That seems like a reasonable goal, right? We do want sex trafficking's terrible, it has many victims, it ruins people's lives. So we want to limit sex traffickers' ability to use social media. But what ended up happening? Because of this broad, vague law that Congress passed, weakening platforms' protections for content related to sexuality, what ended up happening is resources for sex workers, resources for victims of sex traffickers got taken down. Sex workers who voluntarily wanted to use these platforms as a way to connect with their customers because it's safer than standing on a street corner, they got kicked off of many platforms. Platforms started adopting broad policies limiting all sorts of sexual content that had nothing to do with sex trafficking. So the point is that, again, like the reason that Congress passed Section 230 is that it realized there is going to be bad content and there's going to be good content. And part of free speech is platforms and users getting to decide for themselves, how are we going to draw lines between what we're going to leave up and what we're going to take down? That's not for the government, and that's not for plaintiffs bringing lawsuits. That's not for the courts to decide. It's for us to decide.
So that makes sense to me. I want to take a moment here. I want to bring in some YouTube chat, basically, what's happening in our YouTube chat live. We have Ian Heron saying private companies limit free speech all the time. This is about the government limiting free speech. Then we have Annie saying Section 230 has allowed companies to ignore abuse and harassment on their services. I see, Megan, you nodding from the periphery here in my eye. And because of that, I kind of want to take a moment and let's listen to Matt Schewers. Matt is the president of the Computer and Communications Industry Association. And he's talking about what might happen from the perspective of tech companies if Section 230 were to change.
If we ratchet up liability rules, you get two potential results. One is that services over-moderate, over-filter, over-sanitize their content to ensure that there's no potential risk of liability. And the other is that they throw up their hands and abdicate responsibility. We want companies to moderate, to take action against content that violates their terms, that makes their communities less safe. But they're not going to get every single call right. And if courts penalize companies that miss needles in haystacks, that sends a signal, don't look at all. And that turns the internet into a cesspool of dangerous content.
I mean, Mukund, isn't it already broken? I mean, it seems a bit confusing to me. I mean, the internet certainly seems that way.
There are a lot of problems with the internet, and there's no getting around that. But the problem is not Section 230. Look, I am no friend of the big tech companies. They have a lot of problems, and they're doing a lot of things wrong, a lot of which we should criticize them for. And to be clear, I'm not saying that there's no legal path or nothing the government can do.
Oh no, I appreciate the nuance, and I know that it's not black and white. So yeah.
But to give an example, like if we're concerned about the power of these big tech companies, there are other laws to do something about that.
Okay.
When companies do something bad, what normally happens is consumers go to another company. That's how a free market is supposed to work. But that's not how it's working online. And that's because these companies have become so big and powerful. That's what antitrust laws are for. Part of the reason they're so big and powerful is they have all of our data, so they're able to use their algorithms to lure us in and so on. That's what consumer privacy laws are for. So there are other laws to hold companies accountable without regulating speech.
Yeah, and Julie, I know you want to jump in. I mean, obviously, we all can agree something needs to be done about this, specifically about harmful content online. But Julie, I would imagine you don't think big tech should be getting a pass as they have?
No, they shouldn't. And I think one thing that this case is highlighting perfectly, it's the need for transparency on how algorithms work. Because right now we're making assumptions, a lot of assumptions. There has been research, but most of them external. So that case would make a strong incentive to shed more transparency and oversight of algorithmic moderation and recommender systems. Now, when it comes to how to deal with that, how to deal with big tech, well, certainly the way is not going to be governments having to tell us what should be online or what shouldn't. That's extremely dangerous. We all know it historically. Yet, that doesn't mean companies should get away. But at the same time, we have to recognize the limitations. Here we are talking about Section 230 for Web 2.0 platforms. So the Facebook and Instagrams and the Googles, YouTube, and the likes. But we are on the brink of changing all that. We're already talking about immersive technologies, and I'm thinking, of course, here about metaverse. We're also talking about decentralized platform. How do you do moderation? How do you moderate recommender systems, if there are any, on decentralized platforms? These are extremely important questions to be dealt with. And with this narrow angle, it doesn't allow us to have this bigger conversation.
So, Megan, I know you want to jump in, and before you do, I want to share with our audience on Twitter. I think this is your organization tweeting this out. I was ripping my hair out, especially at the beginning of the oral arguments. This is what people from your organization said about what the justices got and didn't get about algorithmic harm. Now, I think what that underlines for me is that I don't presume to understand the algorithms, and I'm not trying to poke fun at the Supreme Court's knowledge per se, but I do have to say, algorithms are not so simple, and it's not as if, in this case, the tech company is kind of also telling us through the algorithm what we want to see. It's not like we're only looking for things, right? Is that a fair way of putting it?
Right. It's not that you're finding the content. The content is finding you. The tech companies targeting algorithms don't just show people what they want to see based on their own inputs. Tech companies collect massive amounts of data on users, like how they interact with the company's website and their location, and then they make inferences about their users, and then they recommend content based on those inferences. So what you see is like what the tech company thinks is most likely to keep you on the service, so they can serve you more ads, which generates more revenue for them.
Right.
And like the effect of that algorithm can be, either they think, a stream of cat videos will keep you engaged.
Yeah.
But, also a stream of extremist content might keep some people engaged.
To be fair, no, most certainly. And it's, go ahead, Mukund. Yes, please.
I agree with Megan on that. I don't like the framing that the tech companies are just trying to send us content that we want. I think that's often giving them, that's being a little bit, the truth is a little more profit oriented for one. I mean, they are, as Megan said, trying to sell us ads. They're trying to keep us on their platforms where we're a captive audience. And so they're not doing this out of the benevolence of their heart. But we do need to make sure there is speech protections for the many other smaller platforms that are trying to serve the public, that are, sometimes groups of people just get together. They want to create a website or a forum or a blog. And Section 230 protects those people also, and they need to have breathing room because the Google's lawyer acknowledged this at the Supreme Court.
Fair enough.
If the Supreme Court weakens 230, Google might stay alive. It has lawyers. It has great law firms, people working for it that it can fight lawsuits with.
Sure.
It's the smaller platforms that are going to get hit. And so, again, I agree with Megan's concern about the way these companies are collecting this data, the way they're designing these algorithms to lure us in. And again, the solution is not to attack the algorithm, the recommendation that this is a publishing act. That's an act of speech. We should go after the way they're collecting this data, because privacy is also an important right, and one that we should talk about more when it comes to these
It is, and we're going to try to get all this in the last few minutes of this important conversation. So if you just bear with me, I want to share with you a clip from February 21st. This is when the Supreme Court held oral arguments on the issue. Take a listen.
I can imagine a world where you're right that none of this stuff gets protection. And, every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass? A little bit unclear. On the other hand, we're a court. We really don't know about these things. These are not like the 9 greatest experts on the internet.
There is no word called recommendation on YouTube's website. It is videos that are posted by third parties. That is solely information provided by another. You could say any posting is a recommendation. Anytime anyone publishes something, you could be said it's a recommendation.
Well, the videos just don't appear out of thin air. They appear pursuant to the algorithms that your clients have, and those algorithms must be targeted to something. And that targeting, I think, is fairly called a recommendation, and that is Google's.
I guess watching that, or hearing that, I should say, Megan, I'm wondering, I mean, so many questions come to mind, right? Like, what role do algorithms play in promoting extremist content? Specifically, or causing real-world harm. But then if we go back to the profit question, I mean, many people seem to think that algorithms are somehow inherently more neutral than human beings, right? That human beings might have bias, but an algorithm's designed not to. Is that true? I mean, I think your statement, Mukund, about, and this is just my personal opinion, just having covered tech companies, and these apps aren't designed for free expression or all the lofty wording that the companies put out there. I think they're designed for profit. Why is that such an important part of this debate, Megan? And when we look to the next steps, like, what are the solutions in your mind, Megan?
So that's exactly correct, that the algorithms are designed for a particular purpose, and they are to make a profit for the company, and that they're designed by people. And people have biases, they have objectives, and these wind up in the algorithms. So yeah, it's a major misconception that algorithms are neutral in any way. There's no such thing as a neutral algorithm. And the thing is that, oh, sorry.
Please, no. I'm so sorry. It's just I want to try to get in. Mukund, I'm actually, because I interrupted, if I may, I want to get in the privacy law aspect of this. So to do that, I want to share with you a video comment that was sent to us by Caitlin Vogue. Then we'll come back to you, Mukund. Take a listen.
Section 230 also encourages services to voluntarily moderate content like hate speech and disinformation by ensuring that those who moderate are not at greater risk of liability than those who don't. But Section 230's liability shield is not absolute, and it doesn't apply to claims that have nothing to do with third-party speech, like those based on competition or privacy law. Comprehensive federal privacy legislation could address some of the harms that are caused by providers' collection of users' personal data and the algorithmic recommendation of content like that at issue in Gonzalez.
So, Mukund, how could antitrust and privacy law actually address the content moderation problem? What do you make of what Caitlin had to say there?
I think Caitlin is very on point here. And this is really important because when we talk about things like bias and profit, those can be bad incentives, but they do not eliminate protection for speech. The New York Times is biased. It's pretty clear from its editorials. It also makes profit. It's a company, but it's also very clearly, it has free speech rights about what it says and how it says it, how it appeals to readers and so on. And Caitlin's right that rather than going after, and people have been concerned about the dominance of traditional media for a very long time, but the government has never been allowed to go after their speech rights. So if we are worried that Google has this huge platform where everyone's going and it's hard for people to leave because of its algorithms, let's look at whether it's violated antitrust laws. If the reasons that its algorithms are so effective and are recommending bad content to people, are luring people in, and frankly, it's hard to leave, social media is addictive. And part of the reason for that is they have designed these algorithms so effectively based on all of the data they've collected on us.
Right.
So then let's do something about that data collection.
With the incentive, with the objective of earning money. Okay, we have the last word. I'm going to come to you, Julie. Go ahead.
Can we briefly discuss this? Yes, this has been done in the European Union, where the Digital Services Act right now prevents platforms from targeting minors, for instance. But beyond that, when we talk about Section 230, we should think about the broader context as well. Any decision that will be made will have incredible important international impact, given the interconnectedness of the space that we're talking about. We could end up in a space where what is allowed in the United States becomes totally forbidden in other countries. How do we reconcile this as an internet community? How do platforms reconcile it? That's their problem. But really, the question is, how do we continue to make sure that the internet, social media spaces allow for speech, including speech that we disagree with, and including speech that help us understand the world as it looks today?
All right. Well, you know, I have so many more questions for you three, but I want to thank you first and foremost for joining us on this show. That's all the time we have for today. Thanks for watching. Thanks for joining us, and see you next time.